Pardon?
We're
Yeah.
live.
Yeah.
Hello, hello. Welcome. We are live. We're just setting up on Instagram and then we are good to go. So, hello, everybody. Trust you're all well, having a great week. We've got a jam packed session today. I'm quite excited. We're talking about frequently asked questions regarding trusts. So, my name is Richard Answer and this is Sonia Mendy. Sonia is the private wealth executive and marketing lead in the company. I'm the founder of Once Wills and Trust. So, hello everyone. So over to Sonia.
So today we're going to be talking about trusts. I feel like there's a lot of people out there that do have few questions about what a trust actually does, what it actually is. So what I've done is for today's little live, I made a list of frequently asked questions that people tend to ask about trusts, probably something that you'd probably want to know yourself. So just to begin with, probably the most basic question possible, Richard.
Okay.
What is a trust?
Okay. Good question. In layman's terms, in my own understanding, I'll just explain that way. So, trust is I class it as a device or technology which allows you to separate full title. And maybe I should backtrack. So, everyone has anything that you own in this country anyway. You have full title to it. So the best way to explain that is if you do your shopping at the supermarket, uh, everyone or most everyone should once you paid at the till, you come out with this receipt, and that receipt just confirms that you own the items in that basket. So that receipt confirms you have full title. If you own a house, you have full title of that house. Let's forget the mortgage scenario just for a second. So a trust is a device that allows you to separate the full title into two different types of ownership. So one's called beneficial or equitable ownership, and one is called legal or possessory title ownership. So, and effectively, what that means is you have a beneficiary that's created who enjoys the use of the property, and then you have a trustee that's created that is responsible for the administration and management of the trust itself, and they effectively are the legal owners of that property. So yeah, that's the simplest way I can explain the trust and break it down.
Okay.
Hopefully, it makes sense.
It does, it does. Thank you.
Yeah.
So then what are the most common types of trust would you say then?
Well, there's really only uh, three types of trust. There's lots of marketing speak out there with different names and titles, and sounds quite grand. But really, there's only three types of trust. So you got we call a bare trust, which is the most basic, I guess, of trust. Some would argue that it's not really a trust, but let's keep it really simple. So a bare trust is that same device. You have beneficiaries, you have trustees. Uh, the only difference, I guess, or specific with a bare trust is that the trustees don't really have any power. They are just looking after that item on behalf of the beneficiary until the beneficiary either reaches a certain age or they reach a certain age and requests or command for that property to come back to them. So yes, that's a bare trust, and you have something called a discretionary trust, which is probably the most powerful type of trust, where the trustees have absolute discretion, have very flexible powers to make decisions, and then they can even decide when the beneficiary can benefit both from a capital element and also from an income element. So yeah, so that's the most powerful type of trust. And then you have something called an interest in possession trust. I know it sounds very techy. Uh, it's kind of like a hybrid of a discretionary trust and a bare trust. So effectively, the beneficiary can enjoy the income and do what they want with the income. Okay, but when it comes to any capital, the trustees have absolute discretion over what happens with the capital. So that's what we call an interest in possession trust. And the only real differences, I guess, with trust is that they can either be created during lifetime or upon death. So that's a long short of it.
So just can you have trust both lifetime and both death trust as well?
So yeah, well, so the only way to have a trust created upon death if it's written within your will,
Mm-hmm.
or there's a variance of that. So that only becomes alive when someone dies, but at least it's written to take effect.
Hmm.
And in a lifetime trust, yeah, if anyone wants a lifetime trust, as long as it's established and set up correctly,
Hmm.
then you could effectively have both. Yeah, from
Okay.
that point of view, definitely.
So what are the most like typical reasons why people are pushed to get a trust? What usually makes people want to get a trust?
Um, it depends really. I think most of the queries that we get is, they want to create generational wealth. They want to protect their children, or they've got inheritance tax challenges, and they want to. The first question is, "Oh, I need a trust for inheritance tax," which is not always the right option, but that's always the number one question.
Hmm.
Um, so most people are concerned about protecting their assets. That's normally the main thing that query that comes about, and they've heard about trusts, and so they want to find out more what they can do to protect their loved ones, and make sure that the assets are passed down directly to them,
Hmm.
rather than going to a third party, and also to kind of prevent any kind of family challenges that people have probably experienced a very negative um, scenario with either a loved one's passed away, it wasn't very well organized, they've seen the very ugly side of what could happen, and so they're determined not to have it repeat in their own personal circumstances.
Okay. So then, how long do trusts usually last for, or when do they come into effect?
Well, in England and Wales, they'll last for 125 years. Um, they come into effect, you could argue immediately, but to be correct, I know people are going to try and correct me. Um, if it's one that's written down and expressed via a declaration of trust, then
Hmm.
it becomes alive once all parties have signed. Um, so yeah, I'll leave it there.
So I'm aware a trust is like split into, let's say, parts:
Yeah, yeah,
the settlor,
yeah,
the beneficiary, and the trustee.
yeah.
Um, so how do you know a suitable trustee? How do you pick a suitable trustee? Because
That's actually a really good
their
question.
role is to manage the trust, right?
Yeah,
For the benefit of the beneficiary.
yes,
But
absolutely.
then how do you know? Yeah, basically that the
No,
question.
that's a really good question. I think these are one of the questions that why it's so important for people to get trust advice, because they just choose anyone who they think might be a good fit, even with executors,
Hmm.
and they're not a good fit. Um, it's just really bad. So a trustee, as it says on the name on the tin, needs to be able to be trusted
Hmm.
to act in the best interest for the beneficiaries, and also to carry out the settlor's wishes, um, both during lifetime and when the settlor's no longer here, um, upon death. So they're called fiduciaries, so they must act responsibly. They're going to be handling money, or someone's wealth, and they need to be able to make the right decisions, understand the law surrounding the decisions that they're making, understand the law surrounding the trusts,
Hmm.
understand the tax element, that if there's any kind of potential taxation that could arise, um, and making sure that the decision is right for the beneficiary. So it could be lay people, doesn't matter, or you can have professional trustees, but ultimately they need to be honest, be above reproach, so that the beneficiaries can trust them and do things, and they're going to do right by the beneficiaries and not by themselves. So the challenges that I've seen, I've had trustees who unfortunately they're children of the settlor, and um, I think the worst example I've seen is, uh, unfortunately, a lady who's diagnosed with terminal illness. The life insurance company paid out during lifetime. Uh, there's two trustees, siblings. There's one daughter, one son, and one of the trustees refused to agree. With trustees, how trust works, all the trustees have to agree before a decision can be ratified or made. So if one disagrees and one agrees, then nothing can happen. And so, unfortunately, in this scenario, one of the trustees deliberately didn't agree for anything for the mum to get the money in their lifetime to help with their care and peace, because they wanted the money for themselves as beneficiaries, and that's
Hmm.
just a poor situation. Um, Yeah, I've had situations where siblings are fighting, so they refuse to speak, so they're being belligerent and obnoxious, and refuse to sign paperwork, refuse to communicate with the lawyers, so nothing can move forward. And so that really just makes it an antitrust. It just ruins the whole planning. If the trustees cannot be responsible
Hmm.
or emotionally intelligent, uh, regardless of any personal scenarios, they can set that aside and make the best decision for the beneficiaries, regardless of having a fight of an argument with the mum or dad or whatever.
Yeah.
Business is business,
Hmm.
personal is personal, and if a trustee cannot separate the two, or worst case scenario, you've got a yes man or yes person that whatever the beneficiaries say, the trustees will do, which is kind of operating more towards a sham, I guess. But it really does make a massive difference as to who you pick as a trustee, without a doubt.
Okay.
Yeah,
Thank you.
that's fine.
So I just had a quick thought, just
Yeah.
coming off that. So you know how our once stands for own nothing, control everything,
Yeah.
and obviously trust can play a part in that.
Mhm.
With a trust, is there usually an owner? Because this is something when I was learning about trust, I was kind of trying to get. You remember, I didn't really understand
Yeah,
it.
yeah. That's fine.
So just about like the ownership and not having ownership in a trust, and how the person who sets the trust, can he be a trustee as well?
Mhm.
Like, can you just explain that just for some clarity?
So in terms of who owns the property,
Yes.
yeah.
Yeah.
So okay, so I'm going to use this calculator just for kind of a visual aid.
Hmm.
So at the moment, I own it. Okay, let's say for argument's sake, I own it, and so it means that I have the full right, title, and interest, if I'm talking legally,
Hmm.
and equitably in this item. So no one else can claim that it's theirs. No one else has an interest in it. I can show proof of purchase. It's mine.
Hmm.
And so that makes me the settlor. I'm the creator of this trust
Yes.
that we're going to create.
Hmm.
And I don't even need to know that I'm creating a trust. I just need to have the intention
Mhm.
to make sure someone else is benefiting from this,
Mhm.
and have the intention that someone else is going to look after it on behalf of the person who's going to benefit. As long as my intention is very clear, then a trust it will be created. So if I gave this calculator to you, and I said, right, well, whenever I want to use it,
Mhm.
you'll provide it for me.
Yeah.
Then now I've created a trust. So ultimately, you're holding that item. Yeah. So you have possession of it.
And you're still technically the owner.
No.
You're no longer the owner
No,
after.
no longer the owner. See,
So who's the owner then?
so because you have possession of it,
Yeah.
so you have we call a possessory title.
Mhm.
And whoever holds the title really is the owner. Okay. So, and then we've got two different worlds. I can't keep it really simple.
Mhm.
But we have two law forms in the UK. Okay, we've got common law, and we have also equity.
Mhm.
And so there's an argument of who's the real owner. So in common law, then the trustee is the legal title owner.
Mhm.
And so you would be the one responsible for maintaining it and claim that it's yours
Mhm.
or on behalf of the trust. In equity, as a beneficiary, I'd be considered the true owner.
Okay.
And trusts actually reside in the jurisdiction of equity, not the jurisdiction of the common law. So it depends on who you speak to, but ultimately, the trustees are responsible for the legal maintenance of that item.
Okay.
And I guess the trustees are duty bound to make sure the beneficiaries, which would be me,
Yeah.
has use of it according to the rules and what was ever agreed with the trust.
Mhm.
And so if the batteries need to be changed, that's the trustee's job. If it needs to be upgraded, that's the trustee's job. But if I need it to do my calculations, then the trustee needs to provide the beneficiary with the item.
So how does a trustee actually benefit from a trust?
No, the trustee don't benefit. They're not even deemed as owners of it. So their personal items are completely separate
Mhm.
to the trust. So you can't say, so trust property is trust property. There's a term about being special, a special property. So it's set aside. It's not commingled or mixed with any other items.
Mhm.
So, you know, if this calculator would probably go in a special trust box
Mhm.
to do with the specific trust. So it wouldn't go in a general box with all of the other items used by me personally.
Mhm.
it will go in a special box for the trustees to access as and when they need to. Just like a bank account, there'll be a special bank account outside the realms of a general purpose and specifically used for the trust and the trust only, no other item. So you can't go and do your general shopping with the money, or I can't go and give that to my mate down the road to use his calculator because I have no right or power to do that.
Yeah.
It's for trust use, and as a beneficiary, I have the right to utilize it within the realms of the trust. So the trust owns it, but the trustee administrates it. So hence the control, because the settler would have written down the purposes or the rules as to when and how the calculator could be utilized. So they still have control, but they no longer own. The trust owns. So, and then where I say the secret to wealth, because if I don't own it, you can't tax it, you can't take it from me. Because in this world, in this Western world, proof is down to title. Land that you walk on, the car you drive, everything you own, even though it's physically in your hand, if you can't prove you own it, it's not yours. Right? So ultimately, it boils down to if you have a title or not. And everything has a title. Even the tin of baked beans you buy, you have a receipt for it. So, and it's itemized. So every transaction is itemized. So therefore, everything has a title. So really, it's like the Matrix. You're just seeing everything in numbers. If you wanted to, rather than the real physical world of, well, this is mine and that is mine. And so we think if we own things, then we accumulate wealth. But then you're taxed more, and you're more prone to all the other threats to wealth. So let's ring fence that and be savvy around it.
Okay. So then, what type of things can you not put in a trust?
You can put almost anything into trust, but it's got to be identifiable. There's a rule of certainty. I'm not going to start quoting case law and stuff, but ultimately, there's three forms of certainty. So certainty of the subject, the property, it has to be certain. So if I've got 1,000 silver coins, well, how am I certain which one is in trust and which is not? If I've got 10 bottles of wine, well, how do I know? And it's in the midst of 100 bottles of wine. What bottles of wine are in the trust? So we got to make sure it's itemized correctly. We're completely certain what is the property, so that, or the subject matter. Okay, and then we've got to look at the intention of the settler. Well, did you actually need to create a trust, or was it by accident, or was it for the wrong means? And then you've got certainty of objects, so the beneficiaries. Does a beneficiary exist? Are they a real person? And do you have the ability to receive the item correctly? So ultimately, if those boxes are ticked, then we can prove a trust exists.
Okay. Yeah. So with the trustees, you can have obviously more than one.
Yeah.
Do they have to make a joint decision, or can they make separate decisions?
They have to make a joint decision. If there's only one trustee, then obviously, but hence the safeguarding is having more than one trustee.
Okay.
So if it's a decision that needs to be made and one disagrees and one agrees, then nothing can go ahead. Everyone has to agree in terms of trustees in order for a decision to be valid and to proceed without doubt. These are great questions. Thank you.
Some of them are just, slipping off the tongue. So I just wanted to ask quite a common question that we get. Yeah. Can I put my house in a trust if there's a mortgage?
Yeah, it'd be we call the equitable title of the house. So for conceptual reasons, if your house is £300,000 and you've got a mortgage of £100,000, providing your mortgage lender is happy and there's no terms that will violate you transferring your equitable portion to another entity, then that can go into trust. Yeah, definitely.
Okay. And people usually have this kind of thought that trusts are associated with the rich people. What's your
what is rich? That's all relative today, isn't it? It's just all relative today. But no, I get what you're saying. once upon a time, you could say that because the trust had a heyday, shall we say, probably nearing 20 years ago, where you could put absolutely as much as you want in a trust. And so for those who are significantly wealthy, it's a very, very, very powerful tool. And the tax man has kind of put a cap on that now. So, there's other ways and means of emulating that type of situation. But ultimately, in my mindset, everyone who wants to create generational wealth for their loved ones should be thinking in the realms of setting up a trust. Wealth is relative, but if you work hard for what you've got, and you want your children to benefit or your loved ones to benefit from that, and not it being squandered, then this is probably the best advice to utilize.
Okay. So thank you.
Right.
So just going back to the question of trustees, what is a professional trustee?
A professional trustee, it's actually a really good question because there's a lot of confusion around that. Even I get confused sometimes. So ultimately, I keep it really simple. It's someone who is deemed to be competent in the area of trusts administration because it can be quite complex. And so they would understand, say, the tax regime, the trust rules, estate administration, and so they can guide, make help towards a decision process for anything that goes on towards the beneficiary. Then there are trust corporations. I guess that's a confusion, which is a different kettle of fish altogether. So it's just a corporation can act as a trustee, but it's a company rather than an individual. And the thought process behind that is that a company will outlast the lifetime of an individual. And so the trust will not fail for lack of a trustee, because you have so a professional trustee can be a corporate trustee, should I say, a trust corporation. But to keep the answer simple, it's just someone who's not a lay person who has more advanced knowledge in the area of trust that can assist with the decision making.
Okay, thank you. So, just what is a trust of land, would you say?
Well, actually, that's a really good question.
All the questions are really good.
Yeah, it is actually a really good question because it's not commonplace.
Yeah.
So historically, or by law, land is land, and every land has title, and so when you convey land, then a trust is created. So there's a specific statutory legislation for trusts of land, and it needs to be so because it's a physical item, so we say, or it's physical in nature, and someone has to own it. Then a trust is pretty much created, and they've got a legal title, and then we talk about beneficial title. So a trust of land kind of embodies all of that. However, terminology is also utilized for the essence of a trust. Now, trust can be created by your words only, not necessarily just by what's written down. Okay. Some people call that an implied trust. And so when you're buying land, so an example would be, I don't know, parents buying property for their children to go to university. And the parents never lived in the property. They've never enjoyed the benefit of the property. They just maybe they pay the bill, or maybe they don't pay the bill. Let's say they don't pay the bill. So they put the deposit down. So that makes them a settlor. Their intention was always to benefit their children or benefit their child. So their child is the beneficiary. And they're just trustees. They're just administrating on behalf of their child. They haven't lived in the property, so they haven't enjoyed its use, so there's no benefit from that. They're not receiving an income. Maybe the child is responsible for the income received. So you call that an implied trust of land. And so you'd start to involve things like the Law of Property Act, and other legislation, and mainly down to equity. You say, well, an event's taken place, it's been many years, we can prove factually that nothing's happened that's going to violate a trust, especially from a tax perspective. And so we just give it its marketing speak, a trust of land. So we express in writing now because the trust can be expressed either by parole, verbally,
Mhm.
or by declaration or in writing. But obviously, when it's in writing, it's deemed to be solid and factual, and so
Yes.
we're just um, demonstrating the historical events, which then helps a lot with planning, especially for tax purposes.
Thank you.
Mm.
That was very in depth. Thank you.
I mean, it can be. I'm just trying to keep it really simple. But
Yeah.
yeah.
So, I'm aware of a lifetime trust, but could you just explain what a lifetime trust is?
Yeah, it's just literally a trust created during someone's lifetime.
Mm-hmm.
I know it sounds really simple, but we'll have to differentiate because trust can be created upon, as I said earlier,
Mm-hmm.
upon someone's death, normally via a will. There's a lot more tax advantages doing it that way around, I'll be honest. But you have the option.
Okay.
Definitely have the option.
So, also, here's just another question.
Yeah.
Is it a good idea to put my life insurance in a trust for free?
Yes. Without a shadow of a doubt, having life insurance in a trust, yes. Okay. Now, if you have to, there's a caveat on that.
Mm-hmm.
And in my mind, if it's free, there's always a catch. And you're not getting advice. And let's say your life insurance is 300,000, 400,000, 500,000.
Yeah.
You're going to run into hot water potentially with tax because trusts have their own tax rules. But you haven't been given the advice. You're not aware of the flexibility of the trusts. Discretionary trusts are very powerful, but you need to have the right terms written down, both for the powers of the trustee and also for the discretion of the trustee. And to my experience to date, I mean, I'm not the world's expert. I find life insurance trusts not that flexible. So they'll do the job on the tin, take it out of your estates,
Mm-hmm.
prevent it from delays with probate. All the boxes are ticked, and that in itself is a good thing. But if you're trying to do much deeper planning, i.e., maybe your trust can act as a bank for your children, everyone's talking about, oh, I want my trust to act as a bank, planning for future generational events. Most of the time, I find those type of trusts quite restrictive because the powers are not written in. For example, a trustee ability to create further trusts probably wouldn't be written in there.
Mm-hmm.
The trustee's ability to create a loan,
Mm-hmm.
the trustee's ability to change the beneficiaries.
Mm-hmm.
The discretion is very limited, and the powers are very limited, and then the trustee's hands are tied. So it means, well, how can we do the type of planning that good trust can do with the right advice and planning behind it? And so I would say, especially when the value of your life insurance creeps up to 300,000, 400,000, etc., the tax element starts to kick in.
Mhm.
So I'd really heavily say, yes, get further advice around before putting in trust. If you're trusted in those kind of value rate regions and you care about generational wealth and you just want the option, and then the trustee element, choosing the right trustees, you're not going to get the advice on that because they're not authorized to give you that advice
Mm-hmm.
unless they are, which is fantastic.
Mm-hmm.
But in my experience, not many advisors, and there's some phenomenal advisors out there. But again, it's a specialism. Trusting is its own unique world,
Yeah.
and it's important just to make sure. And then with the regulation as well, if you want to sign that piece of paper, you got to be confident you can back it up. So it's important.
Mm.
Write down.
So, what about putting your business in a trust?
Well, see, it's almost a misnomer. Depending on the type of business.
Mm-hmm.
So if it's a limited company, indirectly that's already a trust. You heard about the corporate veil,
Mm-hmm.
separation of the business owner and the trust or the business assets. Indirectly, that is a trust.
Mm-hmm.
You've got memorandum articles which act as the kind of like the trust regulation indirectly.
Mm-hmm.
So a business, you got to ask for what part of the business are we talking about? If you're a limited company, it would probably be the shares, not the assets in the business, because it's not yours personally anyway.
Mm-hmm.
If you're a sole trader or a partnership, then yeah, you might need to have a discussion around that. depending on what you're trying to achieve.
Okay.
Yeah.
Okay. So I'm just taking another question.
No, that's fine.
What about property investors? Are trusts good for them?
That's interesting. Yes and no. Okay. If you're an investor where you got assets in your personal name and you're looking to, there's an inheritance tax challenge and you want to get some advice around that. The problem is that investors are not treated very nicely by the revenue. Okay, from a tax perspective, right? They don't get no perks. And trusts, from a tax perspective, are at the highest bracket. They're very expensive from a trust point of view and from a tax point of view. And so, property investors, I wouldn't say developers, property investors, have a challenge of deciding what to do. So if they've got a large portfolio in the millions, a trust is just not going to do it because there's a level of what you can put in a trust before it becomes taxed, potentially taxed. What's the word I'm looking for? That's unnecessary. And so we've got to look at other structures. If it's an investor that maybe the portfolio is not that significant, and I'm not saying this, when I say significant, I'm not trying to be rude, it's just, 300,000 versus the 3 million is a big difference. Then it may be the right option. Okay. And the other thing about trusts is time. The time when you make a gift is also important. How much of a gift you make is very important. And then the type of asset you're putting into trust is very important. And so all these, essentially, you'll get the right advice. So for investors, you have to get the right advice. Get options available to you so you can make an informed choice. I couldn't just say carte blanche, yes or no. For developers, because the tax regime for developers are a lot more favorable, then again, there's options and opportunities without doubt.
Okay.
Yeah.
Thank you. So what type of tax traps should people be aware of?
For trusts, the main ones that people may not consider are, inheritance tax is one. It can actually be paid in lifetime, not just during death. Capital gains tax. Again, this calculator, if I bought it today at £1, then I said, I want to give it to my child 20 years later, and it's a special, unique calculator now worth £50,000. Then there's going to be a trigger for capital gains. And most people, but I didn't sell it. The man who sold it, the value's increased. You used British currency. They're going to want their tax on it. That's the story. You gained, they're going to want tax. So that giving it to the wrong kind of person or wrong vehicle could trigger a tax event. Got to be careful about that. If there's loans or consideration involved, considerations like you've purchased something or money's exchanging, you've got stamp duty, land tax. If the value of the property for land is over a certain amount, you've got something called ATED. Then so inheritance tax and your income tax, which everyone pays, but again for trusts, if you're about the right advice, can be quite expensive. And so hence why you've got to get the right advice. Yeah. So those are the tax traps. Any other type of traps I could think of? Most of the time they're pretty much irreversible. So once you make the decision, it's quite major to kind of renege on it or come back on it. So you really got to make sure it's the right choice going forward. So again, it always falls down to get the right advice.
Okay, thank you. So is it worth using trusts in a will?
Yeah, obviously everyone's situation dependent. But I would still say, yeah, if you've got assets, you have loved ones, you want to keep the money more in your pocket, quote unquote, than give it away to the government. Because I think inheritance tax is marginally voluntary. It's just having the right time and the right advice. Then yeah, you could using will trusts are really good. And plus, even if you just want the flexibility.
Mhm.
Let's forget the money for now, just the flexibility,
Yeah.
because no one has a crystal ball for the future. And the rules for trusts within a will are a lot more favorable
Mhm.
than the rules for trusts created during lifetime. So you can change your mind. You've got this 2-year buffer to look at the scenario, look
Mhm.
at the situation, and say, well, nah, it's not worth putting a trust in place, or maybe we
Mhm.
need a different type of trust to put in place, or
Mhm.
oh, there's more family in the mix than we anticipated, or something's happened that wasn't anticipated when the will was first drafted. And that flexibility is really, really powerful.
Mhm.
So it allows you to kind of take a back step, which is really, really good. Discretionary trust. I mean, again, because someone will probably and say, "Oh, you didn't clarify." So discretionary trust has that
Mhm.
specific rule.
Okay.
Um, so uh, just for the flexibility point of view,
Mhm.
tax point of view, especially between spouses, married couples, really, really favorable. Um, Stopping disinheritance for children. There's a lot of blended families out there now. And so how do you stop a child from a different relationship missing out because of either someone being forgetful, in a just inadvertent situation, or just poor planning,
Yeah.
or just complete being horrible? We've seen it. It's just deliberate.
Mhm.
So how do you protect those children in the family? Well, you need a trust in the will. You need to say, right, I want my wealth to go
Yeah.
in this
Yeah.
direction, and it's not going to change.
Mhm.
Um, so just to protect the loved ones. And then we've got those who are vulnerable,
Yeah.
those who cannot make decisions themselves,
Mhm.
and may have access to a lot of cash or inheritance. Um, uh, and then those who may be receiving benefits that may receive a large inheritance, and that could disrupt all of the benefits that they're receiving, rightly or wrongly, but it could disrupt that. And then also there's some perks to the valuation of property, and all those kind of things. So yeah, I can't there's more reasons to have a trust in your will than to not have a trust in your will. I think it's very hard. I can't think of many reasons why you just don't want to have a trust within your will. Most people who say they don't want trust within their will just don't like the complexity of it, or they
Mhm.
see it as more complex than it needs to be, or
Yeah.
they trust their children implicitly.
Mhm.
I trust my children implicitly, but I don't trust that they're going to make the right decisions all the time.
Mhm.
And sometimes you just need to put barriers in place to protect them from going astray without them even knowing.
Mhm.
People can be negatively influenced. You got predatory marriages going on that can affect the direction and flow of wealth unless there's something in the will to make sure that it stays where it needs to go. And then keeping family feuds to a minimum. Um, Really, really important. Too many, when there's a problem in the family when someone dies and the vultures are out ready.
Mhm.
Um, and if there's no control over how that wealth is distributed, it just causes unnecessary problems. It really is horrible. Yeah.
Thank you so much.
No, that's fine.
I just wanted to discuss wills surrounding vulnerable and disabled people.
Mm.
Can you tell me a bit about that?
Well, the tax perks are really good.
Mhm.
Section 89 of the Inheritance Tax Act 1984. If you're receiving certain types of benefits, you can be deemed as disabled. If you're just deemed as disabled
Mhm.
or vulnerable, you could be eligible for that particular tax treatment. Um, and so during lifetime, especially, it's really powerful
Mhm.
because there's no inheritance tax to really worry about. It's more okay, surviving 7 years, but
Yeah.
there's no limit to how much you can put in the trust.
Mhm.
Whereas a regular lifetime trust is capped at say 325. So you could put £1 million in a discretionary trust for someone who's deemed um, vulnerable, disabled, and as long as they survive 7 years of receiving that gift, then there's no tax problems. It really does make it more favourable for them. And forget the tax part of it. Just someone managing the funds for their personal affairs during their lifetime, so they're comfortable, so there's no thefts. Because you've got a fiduciary role now, so someone's not just privately siphoning off the funds and no one knows about it. Now you're a trustee, you have a duty of care to be responsible and have your accounts verified and looked at, etc., etc. It just gives peace of mind to the family that their loved ones will be looked after financially,
Mhm.
and if they put the right wishes in place medically, and their welfare is also taken care of, yeah, it's phenomenal.
Okay.
Yeah, yeah. So there's a lot of perks, and it leads me on to also what's it called when people get paid out for accidents.
Personal injury
Yeah, personal
claims.
injury claims. Unfortunately, I see a lot of people get the wrong type of trusts, um, which is shocking, unfortunately. Because you can get, as I mentioned before, a bare trust,
Mhm.
which most people seem to get. And I don't understand. You get a £500,000 payout,
Mhm.
and the money's still yours, and you're trying to protect it from benefits. The whole reason why you've got legislation in place is that you can still receive benefits because you were not. It wasn't your fault for having an accident,
Mhm.
and then someone sets up a bare trust, well, it's still yours. So your benefits are going to get stopped. Discretionary trust, well, at least it's managed and it's outside
Mhm.
of the realm of uh, the legislation in terms of the authorities, etc. And if you're deemed vulnerable, whether you declare that yourself or there's proof, then again, there's no cap of how much can go in that discretionary trust. Um, so again, it's favourable from that point of view. Now, I see a lot of poor decisions, poorly
Mhm.
drafted trust for personal injury. So again, really important to get the right advice.
Thank you. And also just surrounding divorce as well.
Oh Lord, okay. Yeah, sorry. No.
Yeah, just trust surrounding
Yeah.
divorce. Maybe you can add about a bit about how bankruptcy comes into play with that as well.
So divorce, family lawyers, the UK, England, Wales especially, our laws are quite old when it comes to matrimonial compared to the rest of Europe. And so getting divorced, pretty much, you be prepared to lose half your wealth if you're married and as couples, everything is shared. So if you've come into wealth as so you're single and your family's wealthy, and the family's concerned, well, we're getting married, and maybe there's not an equal parity in terms of the wealth on both sides. And some families may say we'll do a prenup, which they're not legally recognized. They're becoming more and more recognized, but they're not. As far as I understand, I'm not a family lawyer.
Mhm.
They're not overtly recognized compared to, say, Germany or other parts of Europe. But they certainly have a lot of weight now in the court.
Mhm.
Then it would that wealth can be lost sideways
Mhm.
through divorce. And when we talk about um, predatory marriage is a problem because if someone dies, the spouse can automatically receive if the will's drafted correctly,
Mhm.
even though it might be down to you know what's what I'm looking for, just incorrect advice or
Yeah.
being poorly um, deceived.
Mhm.
But all that wealth could just go to one person, and the whole family could be completely disinherited.
Mhm.
The other side of predatory marriage is that if a divorce takes place, then half that wealth will go to the spouse, and that could be deliberate and planned. And marriage itself is a settlement; it's a trust called a marriage settlement. And so uh, the court would look at it from the point of view of a nuptial settlement. Was there an enjoyment as a family unit prior to divorce? So do you have the right to then withhold that wealth
Mhm.
just because you had a falling out? And especially
Mhm.
if you've got young children who
Mhm.
need care, if you're the main breadwinner, blah, 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 then divorce can become very, very ugly. And the laws can get behind trusts.
Mhm.
It can actually get behind a trust fail um, if you've got a decent lawyer and a poorly drafted trust or poor planning.
Mhm.
Okay. So you need to get the right advice. But then the other side, when you look into bankruptcy, there's another realm that we're looking at
Mhm.
called deliberately um, withholding from creditors. And we talked about at the beginning, the purpose of the trust must be valid, else it's not valid or it's a sham. So if you don't have a clear purpose to benefit your loved ones,
Mhm.
I want to create a trust to stop going bankrupt. I want to create a trust to stop care homes. I want to stop a trust. I want to create a trust to stop divorce. Well, that's the purpose. I get it, but there's other laws surrounding there's other laws in legislation that would trigger because the purpose was incorrect, which can then get behind the trust rules because the three certainties I mentioned wasn't incorrect. So it boils back down to getting the right advice, boils back down to having the right plan, boils back down to timing, who you're gifting to, the powers of the trustees. All of that comes in the mix to make sure that you're not caught foul of those rules, that the intent is always clear. And therefore, if all the boxes are ticked, then it's very difficult for divorce to get behind, it's very difficult for bankruptcy to get behind. But if the intention's wrong and it can be proven, then it's all over. So again, it does boil down to having the right advice. Yeah.
Thank you, Richard. Very informative.
I've enjoyed this. I love it. I've actually really enjoyed this. So
it's very informative. Like I'm learning a lot from it as well. So
nice. I could talk all day, but yeah, absolutely. And the reason why we're having these conversations is just to raise the awareness. Our passion is to build generational wealth, to raise standard of education, financial education. There's a saying that financial is expensive. It really is, and we've got to learn to play the game, change the narrative, and make sure that we are utilizing what's out there. And that's our mission to really to educate first as a priority, and then we can facilitate afterwards. So that's cool. And I encourage anyone, if you want to find out more, check out the link in our bio, wherever you're on Instagram or LinkedIn or wherever. We're aiming to produce more content, educational content, actionable content to make sure people are switched on. Yeah.
And definitely follow our TikTok page. We've been posting quite a lot there. So Once Wills and Trusts on TikTok.
Fantastic.
Right. Well, thank you, Richard.
Oh gosh, we're talking for ages. Okay, fantastic. Thank you all for your time, and see you next week.
Bye.
Bye-bye.